Well, welcome to our annual Supreme Court review. Tim and I have been doing this for the last, I think, 7 or 8 years. It's tradition here at Dorsey and Whitney. Our predecessor, Mike Wahusky, did it for probably 20 years before that. We're delighted you could all attend today. Please do remember to sign the CLE sheets to make sure that your respective CLE organizations know that you are here. Let me just introduce myself, Steve Wells, and I'm here with Tim Droske. We're head of Dorsey's Appellate practice, and we also teach the Appellate Advocacy course at the University of Minnesota. We are going to be talking today about the cases, some of the more important cases that were decided last term, and some of the upcoming cases this term that have been taken by the court. I had a friend who, college football fan, who always said at this time of year it just smelled like football. I'm not sure what it smells like right now. Controversy, maybe. There's been a lot of controversy and a lot of high-profile cases coming up. I have to say I'm reminded of my favorite Old Crow Medicine Show song, which begins with, "I hear the sound of tearing pages and the roar of burning paper," because I think we're going to have a lot of controversy in this upcoming term. Tim's going to give us, going to start it off by giving us a few statistics from the last term, which will kind of indicate what an unusual situation we're in with the current configuration of the court. Before we do that, let me just thank Michael Bray, who helped us put the materials together. He did a great job.
Yeah, thank you, Michael. And thank you, Steve. So we'll start with the statistics from this past term. The best place to look for these, if anyone's interested, is SCOTUS blog. They do a great job of, at the end of the term, compiling all the statistics and also keeping track of the statistics as the term progresses. So obviously the big news from the court this past term was the face that you see in the upper right corner, Justice Kavanaugh's appointment to the bench. The confirmation hearings around this time last year were the most contentious that we've seen perhaps ever, and certainly in recent memory, or at least going back to Justice Thomas. And the big question is what the court would look like this term after that, with the same sort of divisiveness and polarized politics that took place at the confirmation hearings translate into how the court operated. The Chief Justice made remarks here in Minnesota in October last year, trying to urge the nation that that would not be the case. And as we'll see from the statistics, it wasn't quite as contentious as everyone thought it might be. First of all, the number of cases decided. As you'll see with this graph, there's been a downward trend over the past decade. Last term, 72 cases were decided. Over the past 10 years, there have been an average of 77 cases decided each term. I've heard the Chief Justice say that the reason for this decline is simply that there aren't as many cases that need the court's attention. And I think anyone can question that. There are any number of circuit splits that the court passes on any term. But at least that's the Chief Justice's rationale. In terms of the outcomes of those cases, about 2/3 of them have been reversed. So if you're able to successfully beat the odds and get your case in front of the Supreme Court with a successful petition for a writ of certiorari, you have a 2/3 chance of the court reversing in your favor. And then, the last third are affirmances. So which circuits do the best in front of the Supreme Court? Well, last term it was the D.C. Circuit, which is the circuit that a number of the current justices hailed from before going on the High Court. And the perpetual punching bag, the Ninth Circuit, again, takes the cake for the most reversed circuit, at least of any circuit that was there more than once. They had 14 cases in front of the High Court last term, and 12 of those, or 86%, were reversals. So what's the voter alignment? With the new conservative bloc, the thought was that there would be 5-4 decisions left and right. Well, the most common voter configuration was 9-0. 38% of the decisions were unanimous. And again, about 2/3 had some degree of consensus beyond 5-4, either 6-3, 7-2, 8-1, or 9-0. It was 29% that fell in the 5-4 category. But even there, the voter alignment was very interesting. Unsurprisingly, I guess, the most common voter alignment was the conservative bloc. So the Chief Justice, Kavanaugh, Gorsuch, Alito, and Thomas. And that happened in that was a configuration in 7 of the 5-4 decisions. But you also had Justice Gorsuch, who joined the more liberal colleagues in 4 cases. The Chief Justice joined his more liberal colleagues in 3 cases, and those are high-profile decisions. And some of those we'll be discussing today. But Alito, Kavanaugh, and even Thomas all switched and joined with Justices Sotomayor, Ginsburg, Kagan, and Breyer in at least 1 case. You also had other cases that just made for even more interesting bedfellows. Justice Ginsburg switching over with more conservative colleagues in a case. Justice Breyer doing the same. Sotomayor, Kagan, and Ginsburg along with Thomas and Gorsuch. You didn't expect to see that all the time when the term started. And another similar case. So you had 10 different majorities in 5-4 cases alone. So a clean, polarized Supreme Court is certainly not what we saw last term, although that was certainly kind of the dominant construction. So who was most likely to be the swing vote? Well, Justice Gorsuch in 4 cases, and we'll talk about some of those today. He had, what's interesting about that, I think, is, in his first half term on the court, he was in perfect voter alignment with Justice Thomas. And that's clearly no longer the case anymore with him finding his own voice. The Chief Justice was second in that respect, and again, on some high-profile cases, certainly was the swing vote. Most often in the majority was our newest member, Justice Kavanaugh. And I think it's fair to wonder whether that's a reflection of his judicial philosophy, whether he is someone who looks to build consensus and is perhaps more moderate than he was painted in his confirmation hearings, or whether this was just an effort to try to build up some goodwill, given how contentious his confirmation hearings were, to show that he can be a team player and isn't an overly divisive individual. The strongest agreement was between Justices Ginsburg and Sotomayor, followed by Roberts and Kavanaugh, Alito, Kavanaugh, Roberts, Alito, and Ginsburg and Kagan. So Ginsburg and Sotomayor agreed in 93% of the cases. Again, notably, Gorsuch and Thomas, who were in perfect lockstep early on, are no longer near the top of that list. Who issued the most majority opinions in 5-4 cases? The Chief Justice and Justice Thomas. And this probably shouldn't be overly surprising either. The Chief Justice has the ability as the chief to assign opinions to any other justice. So when he switches or is that swing vote, he can choose who's going to write it. And if the Chief Justice switches with the more liberal colleagues or something like that, Justice Thomas would then be senior and be able to assign the opinions. Justice Breyer wrote 5 of the unanimous opinions, more than any of his other colleagues. And in terms of who's writing the most dissents, it's Justice Gorsuch with 11. Justice Breyer was next with 10, Sotomayor with 9, Alito with 7, Ginsburg and Thomas with 6. In terms of who wrote the least number of dissents, Chief Justice Roberts, Justice Kagan, and Justice Kavanaugh each wrote only 3. And that's perhaps not altogether surprising. Chief Justice Roberts has really stressed that he thinks the rule of law is advanced more when there are unanimous opinions. And he has been vocal about his concerns about how the court is viewed as an institution, concerns that more and more you're hearing Justice Kagan echo from the more liberal side. And so if the effort is to have the court viewed as less polarized, writing fewer dissents is certainly a way to do that. And again, Justice Kavanaugh might be trying to foster some goodwill and, on the heels of the contentious confirmation hearings by penning fewer dissents. What about oral argument? Well, if you go into court, Justice Sotomayor is going to be the most active. She by far asks the highest number of questions per argument at 23.9. Justice Breyer was second at 18. She's also the most frequent first questioner with 39% of the time she asks the first question. And Justice Ginsburg asks the first question 41% of the time. So if you're appearing before the oral argument, one of those two is going to be asking the first question in 80% of the cases. The difference is Justice Ginsburg is otherwise very silent on the bench. She doesn't ask 0 questions like Justice Thomas did again last term, but she only asked on average about 8 questions per argument, which put her next lowest after Thomas. Justice Kavanaugh and Justice Breyer are both very active questioners. Breyer was second, Kavanaugh third, but neither of them asked the first question in argument last term. So what are some of the takeaways from these statistics? Again, the conservatives do control the court, but the voting alignment is a lot less predictable than many would have expected going into the term. Justice Gorsuch, again, departed from his conservative colleagues in a number of decisions, and so there's a question of whether he's becoming an emerging swing vote, particularly in certain key areas of the law, and we'll talk about some of those in the remaining hour. And Justice Roberts and Justice Kagan continue to be the court's institutionalists. That's reflected by their voting and also, again, comments that they've made in the press recently. And now we'll get into the decisions from this past term. Steve?
First case we're going to talk about today is the census case. This is the case, you may remember, in which a number of cities and states challenged the Secretary of Commerce's decision to put on the decennial census a question about the citizenship. Now, citizenship had actually been on a number of previous censuses. In fact, most of them in the 20th century had some kind of question about citizenship up until about 2010 when it was taken off. And so you'd think that when the cities and towns that challenged this brought the case, that this might be a difficult case for them to bring given the historical precedent. But in fact, there was a problem here, according to the court. So the rationale for Secretary Ross's decision to put the citizenship on this census was that he had been asked by the Department of Justice to include that question so that it could assist DOJ in enforcing the Voting Rights Act. But when discovery was done in the case, it was very clear that Secretary Ross had, from almost the moment he set foot in the office of the Secretary of Commerce, had wanted this question back on and hadn't gotten any request from DOJ. And in fact, it turned out that not only had DOJ not requested this, it was actually Commerce that asked DOJ if they wanted them to put the question on the census. So the court was faced with this. There was precedent for including a citizenship question on the census, but there was a mismatch, as the court said, between the Secretary's explanation for why he put the question on the census and the facts. And the court found that in fact the cities and states did have standing to challenge this action, but it found that this was not a violation of the enumeration clause. That's the clause that says that a census has to be conducted every 10 years. But it was a violation of the Administrative Procedure Act in the sense that the action was arbitrary and capricious because the explanation failed to conform to the evidence about the reason for the inclusion of this question on the census form. And this is a decision that was authored by Chief Justice Roberts, who, at least according to a CNN reporter, actually changed his mind and caused, halfway through the decision-making process, and what had been a 5-4 decision for the administration became a 5-4 decision against the administration. And this was, as I said, held to be a violation of the Administrative Procedures Act. It was a very fractured decision. There's opinions all over the place on various issues that were raised here. But the upshot was that essentially that where, I guess to put it gently, where the explanation for a given action of an administrative agency lacks candor, in other words, conflicts with the objective record, that will be held to be a violation of the Administrative Procedure Act.
So another administrative law-related case was Kaiser v. Wilkie. And this case was significant because one of the items that's been on kind of the conservative agenda for the courts is reconfiguring administrative law, taking aim at Chevron deference, and in particular here what's called our deference, which is kind of Chevron's, I don't know, stepbrother, stepdaughter, cousin. Chevron, you may recall, deals with an ambiguous statute that's entrusted to a particular agency to interpret. And the rule there is that if there's ambiguity and the agency has proffered a reasonable interpretation, that the courts should defer to that. Our deference is the same thing, but one level down. So now it's the circumstance where you have an ambiguous regulation. And if the court looks at the regulation, says it's ambiguous, our deference then says you should defer to the agency's reasonable interpretation of the regulation. And our is named after the case that articulated this standard. It's AUER. And there was a prior decision before that that also had the seminal rock that also applied the doctrine. So the thought was, now we have 5 members on the court, 5 conservatives who are going to overrule our deference. And you had people like Chief Justice Roberts, Alito, Scalia before he passed away, Thomas, Gorsuch, and Kavanaugh, when people tried to read the tea leaves of his former writings, who all seem to have some hostility to our deference. And what's notable is Mr. Kaiser here. The facts of this case aren't really all that important. In fact, the majority opinion says that. Basically, he was applying for benefits from the Department of Veteran Affairs, and the regulations that governed that dictated when those benefits would vest. And so the question here was whether the relevant documents that he brought were in fact relevant under the regulation for when these benefits would vest or not. The agency here, gave an interpretation that left Mr. Kaiser out. He appeals to the Federal Circuit that just says, well, both of you have reasonable interpretations of this regulation. It seems to be ambiguous. We're going to defer to the agency. And Mr. Kaiser then goes to the Supreme Court with the bold question presented of, should our deference be overruled? So he was squarely asking the court to grant certiorari and take up the issue of whether principles of stare decisis notwithstanding, this doctrine should be overturned. The ultimate vote from the court was 9-0 to vacate and remand the Federal Circuit's decision, but it really was a 5-4 fractured vote. Justice Kagan wrote the majority opinion, joined by the Chief Justice on most parts of the opinion, saying our deference survives, but let me re-explain what it means. And the way she re-explained it is a way that the dissent, or concurrence actually, by Gorsuch said, this is a zombified version of what our deference was before. So basically, Justice Kagan said, our deference still applies, but in a much more circumspect way. First of all, the court needs to make sure that there's genuine ambiguity, and even then, not any reasonable interpretation offered by the agency is going to get deference. There needs to be a close look to make sure that this is, pertains to the agency's substantive expertise, isn't just an ad hoc justification, et cetera. Justice Gorsuch, again, wrote a pretty vehement concurrence saying our deference should have been overruled here, and said the decision here is really more of a stay of execution than an actual pardon on it. And so it remains to be seen in future terms that when Chevron comes up, where exactly the lay of the land will fall. Chief Justice Roberts and Justice Kavanaugh both wrote separately to make clear that what the court was saying here with respect to this doctrine has nothing to do with Chevron, again, leaving the door open for how it could be interpreted in the future. And in terms of Chief Justice's kind of institutionalist perspective, he went out of his way to write that, notwithstanding kind of the strong language from Kagan and Gorsuch, the divide between the two really isn't that far, trying to show that there's actually more consensus here in terms of how limited in scope this is than otherwise might appear at first blush when reading the opinion.
The next case, Franchise Tax Board of California versus Hyatt, is important not so much for its decision on the merits, but for, I would say, the practical implications of the result. In this case, which had actually been to the Supreme Court, this was the 3rd time it had been to the Supreme Court, and the issue this time had to do with sovereign immunity. The facts of the case weren't complicated. Hyatt was a wealthy California resident who decamped for Nevada and didn't pay California income tax. So the Franchise Board, which administers California income tax, decided to do an audit of him. Hyatt sued in Nevada the Franchise Board. In other words, the state of California was sued in state court in Nevada. And, in federal court in Nevada. And the question, the first couple of times it went up to the Supreme Court, dealt with issues of what level of immunity and under what states immunity law should apply. This time the question, though, was whether Nevada versus Hall, which was a 1979 case, which held that the Constitution does not bar private suits against a state in courts of another state, whether that case should be overruled. And the court, in a 5-4 decision, ruled that it should be overruled. And the basis for overruling the decision wasn't that there were new developments or new facts or that something had happened since the decision of Nevada versus Hall in 1979. Instead, the court said that the Nevada versus Hall court had misread history, essentially, that it had misread the historical record and, as the majority opinion says, engaged in an ahistorical literalism, which I'm not really sure what that means. But it was wrong, according to this majority, and so they changed it, and they held that essentially California could not be sued in court in Nevada, just completely overruling Nevada versus Hall. So not one, I mean, it's a sovereign immunity case of kind of limited interest on that. The real issue that court watchers noted here was that you have a conservative majority, so this was the conservative majority voting as a bloc, deciding to overrule a previous decision and essentially ignoring stare decisis. And it wasn't because things had changed. The only thing that had changed was the composition of the court. And the dissent in the case noted this specifically, and I'll just read a little bit about this because I think I think it encapsulates the concern that stare decisis may have limited impact now. And this is from the dissent. It is one thing to overrule a case when it defies practical workability, when related principles of law have so far developed as to have left the old rule no more than a remnant of abandoned doctrine, or when facts have so changed or come to be seen so differently as to have robbed the old rule of significant application or justification. It is far more dangerous to overrule a decision only because 5 members of a later court come to agree with earlier dissenters on a difficult legal question. So I think a lot of court watchers look at what happened here and think that this is maybe the beginning of a conservative effort to overrule prior cases in which the liberals were in the majority, not because things have changed, but because the court has changed.
So the next case is Apple Inc. v. Pepper. It's an antitrust case. And one thing that's notable is that in contrast to the 5-4 classic conservative liberal split that Steve described in the last decision, here you had Trump's 2 appointees, Justice Kavanaugh and Justice Gorsuch, writing the majority and writing the dissent, which I don't think anyone predicted would be happening very often when they both got on the bench. So again, this is an antitrust case. Anyone here who has an Apple iPhone might be a putative class member in this case. So anyone who has an iPhone knows that you have to download apps through the App Store. There's no other way that you can purchase apps on your device. But those apps are created by third-party app developers. The allegation here is that Apple has created a monopoly because you can only purchase apps through the App Store. And app developers need to pay a $99 annual fee and have to give 30% of whatever purchase price there is for the app to Apple. Now Apple doesn't say what price the app developers need to set their apps at as long as it ends in a 99. So that's why you never see like 50-cent apps. It's always free or 99 cents or $1.99. The Apple phone users are saying that because Apple has purportedly engaged in this monopolistic activity and you can't purchase apps through any sort of outside network, that they're paying a higher price because the app developers are essentially pushing down the 30% fee and things like that down to the users. This case runs squarely into 40-year-old precedent from the Supreme Court called Illinois BRIC. That decision basically imposed court-created standing to how far antitrust cases could go downstream. the antitrust statutes themselves are written very, very broadly, saying any person can bring suit, and is clearly kind of envisioning consumer actions challenging monopolistic activities. But what Illinois Brick said is that there's a limit to that. So, quick aside, Illinois Brick dealt with concrete blocks and engaging in, monopolistic activities that increase the price of concrete blocks. The contractors would buy the concrete blocks, then sell those downstream, and eventually, the prices for your construction project went up because of the concrete blocks being overpriced. So it was the state of Illinois, very far downstream, that brought an antitrust suit. And the Supreme Court said no. They used language that was that of a direct purchaser, saying, you didn't directly purchase these concrete blocks from the person who you're saying engaged in the monopoly. But its reasoning was highly hinged on proximate causation, that because you're downstream, you're not, proximate cause isn't there in the same way, therefore we're not going to allow you to sue. So you can see where the Apple v. Pepper case creates some confusion, because the app users are buying directly from Apple, so they're direct purchasers on the one instance. But on the other hand, it's really the app developers who are impacted in the first instance, and the app purchasers are downstream from that. So it goes to the Supreme Court, who is tasked with saying, does Illinois Brick apply anymore? Is it overruled? What should happen here? And Justice Kavanaugh joins the four more liberal members of the court and says, and takes, I think, a principled position. He says, look, Illinois Brick uses the language direct purchaser, and here the iPhone users are direct purchasers. And to the extent Illinois Brick isn't a perfect fit here, well, then we should probably just look at the statute to see how broadly or narrowly Congress wanted it to be construed. And when it's using broad language like any person, that would seem to imply that there can be a broad cause of action here. Justice Gorsuch, joined by the remaining conservatives, said, Illinois Brick may be flawed precedent, but it's better precedent than the new reconfigured rule that you're trying to articulate here. And so it's kind of noteworthy where, in the Kaiser case I first talked about, Gorsuch was very quick to want to overrule precedent, but here he's saying, well, stare decisis should probably mean something. And he says proximate causation is really what Illinois Brick was all about. It's what similar kind of court-created standing doctrines are in other cases, and here you're tossing that aside with potentially very dangerous ramifications, where now you're going to have multiplicity of different lawsuits, difficulties in apportioning damages, and it'll remain to see how that all plays out. I think you'll see more class actions, certainly more class actions in the tech space where there are similar kind of models to what Apple has here.
The next case is the gerrymandering case. And it was actually two cases, one involving gerrymandering in North Carolina and one involving gerrymandering in Maryland. So gerrymandering is the art of cracking and packing, as they say, to make sure it's where whoever is in charge of redistricting does it in a way that ensures that certain political parties will have the least representation in the state legislature, or in Congress, I should say. And they, in North Carolina, it was gerrymandered so that Republicans would have the majority, get the majority of the seats, even though they were about equally split in the popular vote. In Maryland, it was the other way around. In Maryland, it had been gerrymandered such that the Democrats got more seats than they would ordinarily be entitled to if you just looked at the popular vote. And there really wasn't, I mean, when you read the court's description of these gerrymandering efforts in these two states, there really wasn't any doubt about what was going on. It was right out in the open. I'll read to you from the court's opinion about North Carolina, and I'm quoting here. As one of the two Republicans chairing the redistricting committee stated, I think electing Republicans is better than electing Democrats. So I drew this map to help foster what I think is better for the country. He further explained that the map was drawn with the aim of electing 10 Republicans and 3 Democrats because he did not, quote, not believe it would be possible to draw a map with 11 Republicans and 2 Democrats. And in the Maryland case, similarly, the court talks about the role of Steny Hoyer, who is a longtime congressman from Maryland, who self-describes himself as a serial gerrymanderer. And in both states, the gerrymandering was just, the partisanship was right out in the open, essentially. So the question that the court asked here was one that they were able to dodge last term. Last term, there was a case from Wisconsin that came up that asked the same question, and the court kicked it back on standing grounds. And here, again, there were standing challenges, but the court didn't knock it out on standing challenges. Here, the court addresses directly the three or four different arguments that were made by the parties opposing this. So it was common cause, for example, in North Carolina. One was that partisan gerrymandering violates the Equal Protection Clause. Another is that it violates the First Amendment Clause. Essentially, the argument is that the First Amendment is violated because the minority is being punished for their political beliefs, essentially. And then the third major argument was that these gerrymandering schemes violate Article 1, Section 2 of the Constitution, which says that the representatives will be chosen by the people, essentially. And the notion was we don't have we're diluting the one person, one vote principle, and what's going on here violates the Constitution because of that dilution. So the court addresses each one of these issues and essentially finds that it is a political question, not a question for the courts. And its reasoning is that there has always been gerrymandering, and there has always been partisan gerrymandering. And the question is not whether gerrymandering is good or bad, one could argue about that, but whether it violates the Constitution. And if we're going to sort of draw lines about this, how much gerrymandering is too much? And the court says essentially there's no way to really determine that this is a question that the framers of the Constitution delegated to Congress and to the state legislatures, and not for the courts. The court also notes that the practical differences and difficulties of trying to determine a standard that you could actually apply. As the court puts it, there's no way, at least the majority felt that there was no way that you could have a standard that was both precise and limited. And because we couldn't craft a standard like this just isn't a role for the courts to play. So the court is open about, they say we're not endorsing gerrymandering, we're not approving it in any way, but we really think that this is an issue for state legislatures and Congress, both of whom have the power to put this practice to an end, if that's how they so choose. This was an opinion authored by Chief Justice Roberts. It is right along the conservative majority fault line, 5-4, all the conservatives in the majority, and a very stinging dissent by Justice Kagan. So Justice Kagan, as Tim said, has authored very few dissents this term, I think 3. Mm-hmm. And this was a very vociferous and an articulate dissent, arguing essentially that the court is acknowledging that there is a violation of the statute or the Constitution, likening this to cases in which the court has found that where voters' rights were diluted, that there was a violation of the Constitution, where the gerrymandering was going on racial bases, that is a violation of the Constitution. But she says now the court is throwing up its hands. When we could find remedies in these other circumstances, but suddenly when it comes to politics, we can't find a remedy. She doesn't think so, and she articulated some standards that she thought that the court could employ. So a very vociferous and articulate dissent by Justice Kagan, but I think this ends the issue. These arguments have been swirling around for generations, really, and now the court has answered the question. State legislatures can pretty much do what they want as long as they don't gerrymander along racial lines.
The next case is an Establishment Clause case under the First Amendment. It's American Legion versus American Humanist Association. And the cross that you see on the screen is the monument that was at issue. This is the Brandenburg Monument in Maryland. It was erected about 100 years ago after World War I to commemorate the lives given by about 40 men in World War I who died in that conflict. And it's on public land, and the American Humanist Association challenged it as violating the Establishment Clause. The American Legion, who helps maintain the public property, is the other party who defended it. The ultimate vote here was 7-2, affirming that this monument could continue to stand. What the American Humanist Association had asked was that it either be demolished, moved onto private land, or else that the crossbeam be removed, its arms be taken off, so it would instead look like a pillar instead of a cross. The Fourth Circuit did find that it was unconstitutional, but again, the Supreme Court reversed 7-2. I think, well, Justice Alito wrote the majority opinion here, and one thing that was kind of squarely in the crosshairs and has been for some time is the court's Lemon test. It's a three-part test that the court first articulated in the 70s, and sometimes pops up in Establishment Clause opinions, sometimes does not. But its general thought was that this would be a three-part test that could be applied kind of across the board, whether you're talking about a monument, whether you're talking about school prayer, whether you're talking about legislative prayer, whatever it may be. And the test is that the law or practice is constitutional if it first has a secular purpose, second, its principal effect does not advance or inhibit religion, and third, it does not create an excessive entanglement with religion. Justice Alito's majority opinion here does not talk about the Lemon test, or it certainly doesn't apply it in any favorable way. In fact, if anything, he tried to overrule it, but he couldn't get the 5 votes necessary for that. He only had 4 people for the part of his opinion where he really disparaged the Lemon test and said it should just be kind of pushed to the side completely. Justice Kagan concurred that the cross was constitutional and said, the Lemon test may be flawed, but let's not throw it out altogether. Justice Alito's rationale for why it stands here is essentially that, look, the cross certainly is a sacred symbol for Christianity, but when this monument was put up, it wasn't intended to disparage any other group or any other religion. And the cross over time can take on a more secular meaning. He pointed to companies like Blue Cross Blue Shield and their emblem as indicative that the cross can mean something more than just what it means with respect to Christianity, and ultimately held that it was okay here, and again emphasized that over the passage of time, these can have on a more, these sacred symbols can have a more secular meaning. Some notable concurrences. Justice Thomas has the viewpoint that the Establishment Clause was not incorporated into the states, and so it has no bearing here when it comes to the state of Maryland or cities or municipalities. Justice Gorsuch concurred as well, but his main point was that he didn't think there was standing here. He said the idea that being offended by a monument isn't the kind of thing that in any other area of law we generally recognize as reaching the level of injury in fact for Article 3 standing purposes, and it shouldn't here either. Justice Ginsburg, joined by Justice Sotomayor, wrote a strong dissent, and Justice Ginsburg actually read it from the bench, which doesn't happen often and is a symbol that it's something that the justice feels passionately about. And her point is the cross is the ultimate symbol of Christianity, and Justice Ginsburg is Jewish. And she said it would not be appropriate to honor Christian veterans with the Star of David, and thus it's not appropriate to have the cross here. Her solution would be not to allow government to maintain long-standing religious symbols, and that the solution is instead to transfer such symbols to private hands. Again, I think the main takeaways going forward is going to be whether the Lemon test has any vitality going forward in any way, and also the question of how much it matters that this thing's been around for a long time. It was certainly part of Justice Alito's opinion, but Justice Gorsuch, in addition to a standing argument, also said it shouldn't matter whether this was put up 100 years ago or put up today. It should be the same constitutional principles that determine whether or not it violates the Establishment Clause, and he would have been on the side of saying, no, this monument's okay.
This term, or last term, I should say, as in the previous, 10 terms, the court took on a number of arbitration cases. Arbitration is obviously near and dear to the Supreme Court's heart, and in the 3 cases this year, they basically reaffirmed the importance of arbitration clauses and the enforceability of arbitration clauses. The first case, Henry Schein versus Archer and White, sales was Justice Kavanaugh's first opinion. It was a 9-0 decision. And in this case, so under the Federal Arbitration Act, the parties can decide who they want to decide the issue of arbitrability, court or arbitrator. And that has been the law for some time. The Fifth Circuit carved out an exception where you could go to court and say that if any claim of arbitrability was wholly groundless, the court could decide that even though the parties had decided on the arbitrator to make the decision. And in this 9-0 decision, Justice Kavanaugh writes, nope, sorry, the Fifth Circuit's exception doesn't apply. We've been very clear about this. It is the party's contract that controls who decides questions of arbitrability, even if a court decides that there is really no claim for arbitrability. The next case is New Prime versus Oliveira, and in this case, the court, for the first time in recent memory anyway, finds for a kind of narrow exception for arbitrability. In this case, there's in Section 1 of the Federal Arbitration Act, there's actually an exception for arbitrations, and the FAA isn't enforceable in certain employment cases relating to certain transportation workers. And so there was kind of a narrow question presented here about whether the plaintiff in this particular case met the exception, and the court found that the plaintiff did and actually enforced this exception provision that's in Section 1 of the Federal Arbitration Act. So it was one of the very few cases that the court has heard over the last 10 years in which the court has not found essentially in favor of enforcement of arbitration in a case in which that's been challenged. The last case is Lamps Plus versus Varela, and this one probably has more significance. In this case, this company, Lamps Plus Inc., had been hacked by a wrongdoer and got some personal information from some of the employees, and then filed a false tax return on behalf of one of the employees. The employee found out about it and brought a class action against the company. Now, the employee's contract with the company, with Lamps Plus, had an arbitration clause in it, but it excluded or was silent, I should say, on the issue of whether or not it would allow class arbitrations. And what the plaintiff argued in the case was, well, I didn't draft this, and it came out of California, and the common law of California is contra preferentum. It should be construed against the drafter, and because it's ambiguous on whether or not it allows class arbitrations, the court shouldn't limit this to just me. The court should allow me to arbitrate this as a class representative in a class arbitration. And the court, in another 5-4 decision, again authored by Chief Justice Roberts, and again split right along ideological lines, said no. The contra preferentum may be a common law rule in California, but that doesn't mean that where a contract is silent, we're going to alter what the court characterizes as sort of a fundamental precept of arbitrations, that you've got to, if you want to have a class arbitration or arbitrate on a class basis, that has to be very clear. And the court essentially, at least in the words of the dissent, federalizes the common law of arbitration agreements and holds that Mr. Varela, the plaintiff in this case, had to arbitrate and had to arbitrate alone and not in a class arbitration setting.
So the next case, Tennessee Wine and Spirits Retailers Association v. Beard, is academically interesting because it's one of constitutional interpretation, and as a practical matter could just impact where and how you buy your booze going forward. So the case involves the 21st Amendment, which is this unique thing in our Constitution. It was the amendment passed that in Section 1 repealed prohibition, and then in Section 2 specifically gave states the authority to pass laws and regulate alcohol. So it's unique in the Constitution in that respect. The problem, of course, is that you're always going to have competing constitutional provisions. And so, all members of the court agree that even though, states under the language of the 21st Amendment are given kind of unfettered authority to regulate alcohol, they couldn't pass a law that, for example, discriminates against members of a certain race being able to buy alcohol, right? That would be unconstitutional, and the 14th Amendment would trump there. Similarly, with respect to free speech. The question here is, what about when it runs headfirst into the dormant commerce clause, which is, again, is one of those principles of the Constitution that's not necessarily slapping you in the face when you read its text in quite the same way as some of the other provisions. And this comes up a lot in the liquor industry. Tennessee, like other states, have imposed residency requirements before you can open a liquor store or get a liquor license. Tennessee's required that you be a resident for 2 years before you can get a license to sell liquor. Well, that was a problem for Total Wines, which wanted to move into Tennessee and is not a Tennessee resident. The Tennessee State AG actually took the position that the Dormant Commerce Clause probably trumps here, and so they weren't going to enforce the law, but the band of local liquor store retailers did fight it and brought a DJ action. So the case comes up to the Supreme Court about how broadly or narrowly the 21st Amendment should apply. And the majority opinion here was written by Alito and joined by, and 7 members of the court voted in that respect, saying the Dormant Commerce Clause wins. And basically, it kind of recognized, well, we can't really focus on the text of the amendment that much, and we can't even focus on early jurisprudence from the court on the 21st Amendment, which was similarly very broad in scope and saying the 21st Amendment kind of says what it seems to mean based on the plain language. But instead kind of looked at the legislative history that preceded it and said that what Congress really intended and then the people intended in ratifying the Constitution was that it's really supposed to mirror a state's traditional police powers. So states can pass laws regulating liquor and trump the Dormant Commerce Clause if it pertains to health and public safety. They said this kind of residency requirement to open a liquor store doesn't have a sufficient nexus to public health and safety to survive a Dormant Commerce Clause challenge. Justice Gorsuch and Justice Thomas, joined by Justice Thomas, dissented. And I think that this shows that even, when you have liberals and conservatives interpreting the Constitution, there's still not always a cohesive unit. Justice Gorsuch focused on the text of the 21st Amendment here and said that's what should apply. And, had language essentially saying if the people wish to alter this arrangement, that is their sovereign right. But until then, I would enforce the 21st Amendment as they wrote and originally understood it. In terms of implications, again, Total Wines can move in. For people, I think in Minnesota, you can't buy alcohol online. That could potentially change. There's been a lot of talk about how e-commerce with respect to liquor could change following this decision.
Timms versus Indiana was a question, was a case that asked the question, does the excessive fines clause of the 8th Amendment apply to the states? In this case, Timms had pleaded guilty in Indiana State Court to dealing in controlled substances and transporting them. The car that he used apparently to transport was a Range Rover that he had bought for $42,000 with the proceeds of his father's insurance policy, life insurance policy when his father died. The actual fine that Timms got for this was about $1,200 in cost, and the maximum fine that could have been imposed on him for the crime was $10,000. He actually ended up getting probation, and I don't think he served any time. So maximum fine is $10,000. He was actually fined $1,200, and the police confiscate and held a forfeiture proceeding over the vehicle, the $42,000 vehicle. He argued this violates the excessive fines provision of the 8th Amendment. The state of Indiana, argued that it doesn't apply to states. Now, you may remember from the 8th Amendment, and it contains a number of different prohibitions. It contains a prohibition against cruel and unusual punishment, which of course has been held to apply to the states in a number of different contexts, not least of which is the death penalty. It also contains a prohibition against excessive bail, which again has been held to apply to the states. And it was an open question, though, about whether the excessive fines clause applies to states. In a decision that was 9-0 on the judgment, so all the justices agreed about the outcome, but for various different reasons, the court found that the that the Eighth Amendment ban on excessive fines does apply to states. The alternative view of this, and the view of Justice Gorsuch and Justice Thomas, who agreed with the outcome, thought that it wasn't the Eighth Amendment that should apply through the 14th Amendment, but that it was the privileges and immunities clause of the 14th Amendment that really brought into play the Eighth Amendment, not the due process clause of the 14th Amendment. So a little bit of a historical or textual difference, but outcome is the same. You can't forfeit, the state can't forfeit a $42,000 car when they can only impose a fine of $10,000.
Before you read the message on the T-shirt on the next slide, just know it's supposed to be intended by pronouncing the letters out loud. So I just wanted to make that clear. The person who designed this shirt never intended the word to be read, but instead just to say the letters out loud. This case is a First Amendment trademark case. Mr. Brunetti designed T-shirts with the red word on it, and wanted to get it trademarked, and the Patent and Trademark Office said no. We have a provision in our statute that says we do not trademark immoral or scandalous phrases, and this is one because it's vulgar, profane, sexually offensive, violent, it can be connotated in a violent matter. We're not going to trademark it. And this case is really just the sequel to the Mattel v. Tom case that came out in 2017. There, the Supreme Court said that the First Amendment barred the trademark law's prohibition on disparaging trademarks. And here it held that it similarly bars the prohibition on immoral or scandalous marks. Where the door is left open by the dissents, and those were by Chief Justice Roberts, Breyer, and Sotomayor. Kagan wrote the majority opinion. Where the door is left open is if Congress were to use a new phrase that would really aim solely at the mode of expression as opposed to the content of it, that could perhaps survive constitutional muster. But when you're talking about morality, that was held to be inherently viewpoint discriminatory. But again, there's a long line of precedent saying that offending words, if it's just that they're vulgar or profane, can sometimes survive First Amendment challenges. But it's in Congress's hands now.
So just to follow up on that, so some of you who have been around for a long time may remember the Redskins trademark case. And that was a case that we actually brought. I was the lead trial lawyer on it in 1992, arguing essentially the same thing, which was that the statute impinged on speech rights, but it's sort of a flip-flop of that. We were essentially arguing in the Redskins case that the Redskins mark was immoral and should be canceled. So it ended up being, after years and years of litigation, decided on laches ground essentially, which was sort of a punt, I guess. But now the question has been really squarely answered, I think, and that you can't stop a mark just because it's alleged to be disparaging or scandalous. I'm just going to go through this very quickly because we do want to talk a little bit about some of the cases that are coming up, but there's one really important SEC case that came up this year, and the question was whether under Rule 10b-5 you can be held to have violated it if you disseminate false information rather than you're the maker of the statement yourself. And the court, in a 6-2 decision, Justice Kavanaugh did not participate, but it was written by Justice Breyer, held that the knowing dissemination of false information can be a violation of Rule 10b-5. The other case was actually sent whether there's a private right of action under Rule 4 or Section 14E of the Securities and Exchange Act was actually held to have been improvidently granted cert, and so was sent back down and may or may not get back up this term.
I won't go into these two cases in detail, but what's interesting is Indian law has proven to be an area where Justice Gorsuch has split from his conservative colleagues and sided with his liberal members very much in favor of Native American Indian rights, something that hasn't been the case with the recent court's composition when Kennedy was on previously. And so in both of these cases, Justice Gorsuch sided with the liberals, the more liberal members of the court, and 5-4 decisions came down in favor of the Native American interests. What's particularly notable is that in the Washington State v. Cougar Den case, Gorsuch wrote a concurrence joined by Justice Ginsburg, where he was quite passionate about Native Americans' historical rights. He ended just with this quick quote: "Really, this case just tells an old and familiar story. The state of Washington includes millions of acres that the Yakama Nation ceded to the United States under significant pressure. In return, the government supplies a handful of modest promises. The state is now dissatisfied with the consequences of those promises and now wants more, but says to its credit, the court today holds the parties to the terms of their deal." So again, this is an area where he seems to be a swing vote in an area that not everyone expected. And transitioning now to the 2019 term, the hardest case for the court to decide last term was an Indian law case, Sharp v. Murphy. And it wasn't able to reach a decision and has set it for re-argument this next term. The issue is who has criminal jurisdiction over the eastern part of Oklahoma. If these are reservation lands and under well-settled Indian law principles from the Supreme Court, they probably should still be construed to be Indian law lands, Indian reservation lands. Then the federal government has exclusive criminal jurisdiction over big crimes like murders. Problem is that it's the state that's been exercising that jurisdiction for over 100 years. And so the problem the court has is if it applies what seems to be the obvious rule of law, you would have hundreds of convictions of murderers, rapists, and other big criminal offenders tossed and on the streets. And the federal government has said, we don't have the resources to fill the gaps. Gorsuch has recused here because he was on the 10th Circuit when this went up for en banc. We'll see what the court does.
Right off the bat this term, there's going to be a trio of cases dealing with whether or not the gender discrimination in the form of discrimination against transgender people or whether being gay constitutes sex discrimination are going to come before the court. And the first case is this R.C. and G.R. Harris Funeral Homes versus Equal Employment Opportunity Commission. In this case, the plaintiff, who was formerly known as Anthony Stevens, so born biologically male, presented as male, was working at a funeral home and announced to the owner of the funeral home that he was going to have transition surgery and that she would be acting like a woman during that period and would be dressing that way. And then she was fired. The question is whether under Title VII of the Civil Rights Act of 1964, terminating that employment on the basis of transgender or transitioning status, or her refusal to conform to sex-based stereotypes because they said she had to wear men's clothes, whether that is a violation of the statute. And in particular, it centers on some very simple language that is highly contentious, and that is whether or not there was discrimination because of sex. That's the language in the Civil Rights Act of 1964. So this will be obviously it's the basis for the funeral director's decision here was religious grounds, and so we're going to have this clash of equal rights, sex discrimination, and probably First Amendment issues that are going to come up. Related to that case, there's two cases. One is Bostock, the other is called Zarda, in which plaintiffs sued their employer alleging same violation of the voting or the Title VII of the Civil Rights Act, but this time because they were gay. So not transgender, but because they were gay. One was a worker in a county office, the other was a skydiver instructor, and they both alleged that when they announced that they were homosexual to their employers, that they were both fired. And the question presented again is whether being discriminated against because you are gay means that you are violating the Civil Rights Act because it is discrimination, quote, because of sex. And the court will have to address that issue squarely.
The court is also going to be addressing the Dreamer program this next term. The Trump administration decided to wind down the Deferred Action for Childhood Arrivals policy. This provides that the policy had provided that undocumented immigrants brought into the U.S. as children could apply for protection from deportation and the ability to work. And there are about 800,000 people who have applied under that program. And the Trump administration is winding down DACA, and one of their main rationales was that the program was unlawful. And you've had challenges brought in California, in federal court in California, the District of Columbia, and New York, and challenging that. The question at this point is, first of all, whether it's judicially reviewable. The Trump administration says that they have inherent discretion and kind of unfettered discretion with respect to immigration-related matters. And then secondly, whether the decision to wind down the policy is lawful. Trump administration again says we have to wind it down because it's not a lawful program. The challengers say it is lawful, and therefore because you're saying you're winding it down because it's unlawful, you have no reasoned decision-making that you're doing here. It's an arbitrary and capricious decision. One thing that's notable is the Supreme Court did grant review in 2 of these cases before it ever went to the circuit court. So, and you saw that with the census case as well. So even though the court's granting review in less cases, it's shown an increased willingness to grant review straight from district court to the Supreme Court.
The last case we'll just alert you to, that is obviously a controversial and kind of a hot button case, is New York State Rifle and Pistol Association versus New York City. In this case, New York City had it had 2 types of permits that allowed people to carry or transport licensed firearms within the city. But if you were going to transport within the city for use outside the city, that was not covered by the permit, and it was held to be illegal under the city ordinance. So that was challenged by gun rights groups. The city then changed the ordinance and has now suggested to the Supreme Court that the issue is moot. The gun owners and gun rights folks say otherwise, and we'll have to see what happens here. But this could be if the court decides that the issue is not moot, it will be deciding yet another case on kind of the limits and the confines of the Second Amendment. And so stay tuned for that. So we're done. Well, we ran a couple of minutes over. Sorry about that. Thank you very much for coming.